Good morning, Your Honor. My name is Martin Prego, and I represent the movement, Chaos Holding Corporation, and Tanith Cross, who is an individual, jointly the defendants. Pursuant to the Federal Administration Act of 1925, the FAA, this is a motion to compel plaintiff Bryce Jennings to arbitration, relying on a valid and enforceable contract which subjects both parties to resolve their employment disputes by binding arbitration and not in this court. So there are three issues that I will be addressing. One is the contract enforceable? And two, is there any issues with the arbitration clause? And consequently, the dispute is encompassed or within the scope of this arbitration clause, which will answer the question: does this court has jurisdictions to adjudicate the disputes between the two parties, and if there's any public policy issues that will prevent these particular claims to be addressed in arbitration. What are the simple facts in this case? Mr. Jennings, the plaintiff, was an employee of Chaos Corporation for about 6 months, from April to October of 2016. Chaos employed Jennings as a district manager, and they signed a contract prior to establish their employment relationship. The other defendant is Chaos regional manager, who was Jennings' supervisor. Other facts at this point are not relevant because the real issue is whether the dispute between the parties should be heard and adjudicated by an arbitrator or here. We believe that this should be heard by an arbitrator, therefore we are filing this motion to compel arbitration. So, one, the contract between the parties is valid and enforceable. At the Court of Arbitration law, arbitration fundamentally requires agreement of the parties. Without a contract, arbitration will not be appropriate. We have a contract here. In this case, we do. And also, the facts show that there are no flaws in the employment agreement. So a valid contract exists. But even though if Jennings will issue claims that the contract is not valid, the doctrine of separability establishes that unless a party specifically challenges the arbitration clause as opposed to the contract as a whole, the arbitrator should be the one considering arbitrability of this sort. Therefore, the challenge party, Jennings, must establish that the alleged invalidity bears directly upon the arbitral clause. Otherwise, it is the jurisdiction of the arbitrator to rule whether there is a flaw in the main contract. In this case, Jennings has not claimed so. The Supreme Court in Prima Paint versus Flood and Concrete Manufacturing reasoned that a contractual dispute involving commerce and fraud, as opposed to arbitration clause itself, is for the arbitrators to decide. And it solidified this posture further by reaffirming it in Buckeye Cashing Inc. and Cardina, basically stating a challenge to the contract as a whole must go to the arbitrator. Therefore, having established that there is a valid contract, and if there is a challenge, should be done by the arbitrator, this is not a question for this court. The second issue under dispute is whether the dispute between the parties is within the scope of the application. The Supreme Court in EEOC v. Waffle House ruled that the language of the arbitration clause determines the scope of the arbitrable dispute, and that the party opposing arbitration has the burden of proving the dispute is not within the scope of the arbitration, and the plaintiff has failed to do this. Therefore, the dispute is within the scope of the arbitration clause and should be submitted to arbitration. Particularly, Clause 9A of the contract calls for binding arbitration when there's a dispute relating to employment, which involves money damages. In this case, plaintiff alleges a claim of protection under the Whistleblower Act, wrongful termination, and assault, ultimately making a monetary claim for damages. Therefore, the alleged claims are employment disputes, and there is a monetary claim. Thus, the dispute is within the scope of the clause. Opposing counsel will argue that when commercial disputes affect public policy, the matter is inarbitrable because of its subject matter. It's true that the traditional view has been that conduct involving, for instance, conspiracies to fix prices is not arbitrable because it's not intertwined with a larger social interest. However, the Supreme Court has ruled that states cannot impede the recourse to arbitration on public policy grounds. If a state law such as the Whistleblower Act or any other statute that may prohibit fixed pricing to be arbitrated, the conflicting rule is understood to be prohibiting or obstructing arbitration, and the conflicting rule is displaced by the FAA. And it was so ruled in Preston v. Ferrer. So in other words, only the federal Congress has the authority to declare certain subjects not to be subjected to arbitration. Today, actually, virtually no federal statute limits the arbitrability of claims. Actually, all claims under statutes promoting significant social interests have been found arbitrable. Therefore, and in conclusion, because the contract is valid, and even if it were not, such dispute should be done by an arbitrator. 2, the arbitral clause clearly encompasses the dispute between the parties. And 3, absent any federal law issuing a prohibition on submitting this particular dispute to arbitration. And more importantly, because both parties have voluntarily agreed to resolve their disputes by banning arbitration, this court should grant this motion to compel the plaintiff to arbitration. Thank you.